Hey everyone, Harry here to talk about Judge Cannon's scheduling order in the Trump Mar-a-Lago case. The order says that the trial will commence in August 2023. So, in the 2-week period starting August 14th, 2023 to be, and go into the calendar to decide when August 8th. So, you may have noticed we're in June. Is that going to hold? Of course not. Is it a joke? Sort of yes and no. So, what's going on? The Southern District of Florida is known, like some other districts, for moving quickly. Eileen Cannon hasn't been an embodiment of that practice, but that they set fast schedules. But what this one really does is simply track the Speedy Trial Act and do a date that would clearly be within it. Now, everyone understands that date won't hold. There will be continuances. When they occur, however, first, Trump will need to waive his speedy trial rights. So he'll be giving up on a certain issue. And there'll have to be a finding of cause by her. It just can't be willy-nilly. So we're starting in August 2023, and that leaves some 15 months until November of 2024. How will those months potentially be filled up? As we've been talking about from the day she got the case, you'll have Trump's lawyers come in and, oy vey, Your Honor. I think they say oy vey down in Southern Florida a lot. I just got the case and I need months to prepare, and we'll waive speedy trial, of course. And then there'll be prosecutorial misconduct motions where they'll want to have hearings and they'll be fighting about what they can have. And then there'll really be, I'll talk about this in greater depth in a future posting, but a lot of back and forth and time taken up by the classified Procedures Act, and they will put in place specific procedures and compromises between DOJ and Trump so that he can mount his defense, but not reveal classified information to the jury. That's a whole kind of wordsmithing thing back and forth. And of course, Trump's lawyers have to get security clearances even to play ball here, and Cannon has already started that as well. So the people who are saying this is a standard order and it won't hold and there'll be a lot of delays are accurate. On the other hand, she said it. She could have, for example, called the parties in and asked about things and made not set expectations, public expectations in any way around such a speedy trial and a quick date. And now, she's got to be painfully aware of the public perception of all of this as she continues to allow delays and continuances. People are going to be really focused and say, what, again? And as we get, to the point where another delay means no trial before November, people will be up in arms. So to me, though it's no demonstration that, oh my gosh, she's, totally gone the other side, and we know she's going to hold Trump's feet to the fire. It is a demonstration that she's trying to play it straight. I think another indication she's totally aware of, chastened by the, absolute evisceration that her reputation suffered because of being in the tank for Trump before. And so she's, doing something that will, create a kind of headwind that'll make it harder for her to do huge delays. Now, even if she's totally on the up and up, what's going to happen is the Trump team is going to say, we have to have 6 months for this. And the DOJ will say they don't need any time, but we'll acquiesce to a week. But what they'll be saying, the Trump team, they'll be kind of brandishing the Constitution and saying it's going to be a due process violation to force us to it. In other words, raising the specter that if she doesn't give them all the time in the world, it will be a constitutional violation, and the 11th Circuit would reverse any eventual conviction. It takes a strong, seasoned, experienced, tough judge to push back on that. And she is anything but. So in addition to the set of concerns that I don't think have been put entirely to bed of just her being biased and in the tank, there's the additional concerns that she just won't be strong enough to really manage the calendar control that a trial by around next summer, when I think it would be the natural lifespan. I'm very big these days on the natural lifespan of a trial. Would come up. On the other hand, she's entered something that she knows is going to put her under really big pressure if she gums it up so much that we're past November. And that's something, I think, and more than a little. All right. So next, there has already been an order entered on the discovery materials that the U.S. passed along to the defense under their legal obligation, kind of notably, and very much shows an awareness of who Trump is. It says he can't disseminate them. He can only take notes. He can't take them away. But they'll be able to start using them to prepare their defense. Importantly, I'm just mentioning it because I want to make the point. This is not any of the classified documents. That whole fight is down the line. The defense hasn't received it yet. Those materials, they do not have the clearances to receive them anyway. So those fights are down the line. This is just about a standard, a big stack that says a lot, including reveals who the witnesses will likely be, et cetera, about the trial, but just not the classified stuff. Okay, so there you have it. They've, got the materials, and we can expect fairly soon the first of many Trump team motions to dismiss the case, delay the case, etc. Till then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.